Hi, I'm Amy Swanner. I'm an attorney and also an AI consultant with Lexara Consulting. I specialize in helping law firms, all the way from sole practitioners up to mid-sized firms, in navigating the ever-changing landscape of AI, whether it be data governance plans or implementing effective AI tools or assisting with AI adoption and integration. My goal is to ensure that lawyers can work smarter and more efficiently and more profitably while still staying compliant. In this session, we're going to dive into data governance. This is a really overlooked area of law for most people. A lot of law firms, even mid-sized law firms, but especially small to sole practitioner firms, feel like they have their data governance under control and that they don't have any problems with data governance, or they don't need a real system in place. We've seen, however, recently, especially in late 2024, that several large law firms have been either entered into settlement agreements for millions of dollars or have been fined hundreds of thousands of dollars for cybersecurity attacks which involved a lack of good data governance. Data governance, data that is not well governed, is going to be more susceptible to risk and more susceptible to cybersecurity breaches. So data governance is incredibly important for your firm. We'll also talk about how AI fits into that and actually can make the situation a lot more difficult if you don't have a good data governance plan. So by the end of this session, you'll be equipped to understand the key principles of data governance, identify the best practices and how AI impacts data governance, and protect your law firm and your clients and their data. So let's start by talking about what is data governance and what that means for you and your law firm, especially in the age of AI. As lawyers, we deal with some of the most sensitive and valuable data out there: client information, privileged documents, financial records, and all sorts of records that need to be handled very carefully. Without a solid plan for managing this data, your firm could be at risk, not just legally, but ethically and operationally. So by the end of this session, you should be equipped to understand the key principles of data governance, identify how AI impacts traditional data governance requirements, and how to protect your data and your client's data from inadvertent disclosure or cyber attacks. So let's start off by discussing what is data governance. Simply put, data governance is the framework that ensures that an organization's data is accurate, timely, secure, and compliant. It's about creating policies, processes, and responsibilities to manage data throughout its life cycle, all the way from client intake to deleting information once it's no longer needed at the law firm. For lawyers, this means having a plan for everything from how you store client documents to how you protect them from cyber attacks or from accidental disclosure. The three components of data governance are: first, data quality and integrity; second, regulatory compliance; and third, data security and privacy. Data quality and integrity means ensuring your data is accurate, consistent, and reliable. Whether it's missing a filing document because you can't find something, or having a motion that's not as effective as it could be because your documents were not in order, or even accidentally disclosing something that's privileged, we have a lot of responsibilities with data. As lawyers, protecting data confidentiality is not optional. It's a professional responsibility. Data governance helps safeguard sensitive information against breaches, leaks, or unauthorized access, ensuring that you comply with laws like confidentiality laws like HIPAA, or even laws like the GDPR or the CCPA. As lawyers, protecting client confidentiality is not optional. It is mandatory and a professional responsibility. Data governance helps safeguard sensitive information against breaches, leaks, or unauthorized access, ensuring that we can comply with laws like the GDPR, which is the General Data Protection Regulation Act in the European Union, or the CCPA, the California Consumer Protection Act, or even HIPAA. Lawyers must ensure that their data practices meet the strict requirements of privacy and compliance laws. So regulations like the GDPR and the CCPA don't just apply to your clients, they also apply to your law firm and how your law firm governs and handles its own documents. That's why data governance is so incredibly important for lawyers, even though it's a lot of times overlooked. The legal profession is built on trust and precision and confidentiality. And without stated strong data governance, you are exposing your firm to legal and reputational damage. You're putting your clients at risk of data breaches or improper handling of sensitive information, and you could even face non-compliance penalties that harm your bottom line. On the flip side, if you have a good data governance program, it can help enhance your work processes by making everything a lot more efficient and effective. So in this session, we're going to build on all of these fundamentals, and over the next 2 hours, we'll explore data categorization and why it's so incredibly essential for law firms. We'll look at leading data governance frameworks and evaluate which ones are best for law firms. Then we'll dive into AI data governance and how that has affected data governance. And then we'll cover data security incidents response. And then we'll wrap up with some practical implementation ideas and real-world case studies that are going to help you be able to implement data governance in your law firm more easily and effectively. By the end, my hope is that you'll not only understand why data governance is so important, but you'll feel really confident in applying it into your own law firm and your practice in really meaningful and strategic ways. Let's move on to our first section, data categorization. And I want to break this down into the types of data that we as lawyers work with. Think of data categorization as really the foundation of effective data management. Without it, even the best governance policies are going to fall short. For lawyers, categorizing data properly ensures that you are putting the right level of protection and care into the data based on its document type and its sensitivity and its legal significance. At its core, data categorization is the process of organizing data into distinct groups based on its characteristics, purpose, and governance needs. In other words, how are you going to be using it and why did you get this? The very first thing that you need to identify is where the data came from, and then how it should be stored, who should have access to it, and what level of security and compliance is required. And finally, how it should be and when it should be disposed of. For example, not all client data is treated equally. A publicly available court document doesn't need to have the same level of protection as privileged communication or work product communication. Data categorization is so important because it serves several critical purposes. First, it protects client confidentiality. By identifying privileged data, you can ensure that it's handled with the highest level of security. Second, it simplifies compliance. Different data types are subject to different rules and regulations, so categorization is incredibly important to help you apply the correct legal and ethical rules. And finally, it enhances efficiency. Knowing what kind of data you're dealing with allows you to prioritize your resources and streamline your workflows. And on the other hand, failing to do that can lead to giving access to confidential information to people who don't need access to it or should no longer have access to it. The key categories for lawyers are common sense, exactly what you would think they would be. First of all, at the very top and most privileged is privileged client information. This includes information received from your client in confidence or any kind of confidential communications between you and your client, such as emails, letters, legal advice, and this is all governed with strict confidentiality. This data must be stored securely, and it should be shared only with those who actually have a need for it. The next is privileged work product information, and that includes, of course, your internal notes or research, drafts of documents, and anything that you've done as part of your strategy or to prepare your case to go to court. Well, this isn't client provided. It should still be marked as sensitive because it is privileged information, and privilege can be waived if it's not treated very carefully. It should be protected so that it is not given away during discovery or privilege waived at some later point. And then the next on the tier is discoverable client information. Non-privileged data that can be disclosed during litigation, such as contracts, invoices, reports, and other things that you'll be relying on in your case, and other things that you can be relying on in your case. Next is general data that can be shared freely, such as your firm marketing materials or publicly available case summaries. And while this data doesn't require strict governance, it still needs to be accurately tagged so that you can keep it aligned with ethical standards. And then public records, which includes court filings, government documents, and other publicly accessible records. These may need to be referenced or used in litigation, but they typically don't require any confidentiality protections. And the second to last category is regulated information. This includes data that applies to specific laws or is tagged as confidential by certain laws such as HIPAA. Handling this data can lead to significant legal penalties, so it has to be really carefully monitored. Next is internal administrative information. Everything that's going to be involved with the operation of your law firm. So things like HR files or payroll records or firm policies or employee records. All of that isn't client related, but it is still sensitive information that needs to be categorized and protected appropriately. And the last category is contractual information. Data arising from agreements with clients, vendors, or other third parties, which still needs some protection, but not as much protection. There's also third-party data that you receive from external entities, people not your client, such as from opposing counsel, expert witnesses, or vendors. This data can be mixed, and so it is imperative that it have very clear tracking to avoid mishandling or violating any agreements. There's also AI-generated outputs. You don't always need to keep track of this, but since some courts require that you disclose if you've used AI tools in your legal research or in drafting any documents, you do need to have another category for this if you're in one of those areas. In fact, it's a best practice to just keep this information in a separate area, protected, so that if you ever need to show it to your insurance provider or show it to the court, you have it and it's there and available. It can be really incredibly useful too if you are looking at your systems for any kind of bias or ongoing monitoring. All right, so let's talk about how you can implement data categorization in your law firm. To implement data categorization effectively, you need to first start by auditing all the data that you already have. You need to inventory everything that your law firm handles or might receive, and then you need to use metadata tagging or some other form of tagging. You need to use metadata and data to tag your documents effectively, or you need to use another solution like some sort of software that can easily tag your data as it comes into your firm or the data that's already there. Then you need to define a policy for each and every category. You should have clear rules that identify the type of information and how it should be stored and how it should be accessed and whether and when it should be shared. For example, privileged client information might require encryption, while public information could be stored in a much less restrictive system. And then, once you've set up these different categories, you need to regularly review and update your categories. Are you getting different information? Are your categories still effective for your law firm? Is there a separate category that you need to add or something that you no longer need? Once your data is categorized, it's crucial to ensure that your access is restricted appropriately. For example, privileged communications should only be accessed by attorneys or paralegals acting at their direction. Once data is categorized, it's crucial to ensure access is restricted appropriately so that only the people who actually need the information have access to it. For example, if you have privileged client information, it should be accessible only by the attorneys that are actually working on that matter or any legal assistants or paralegals who are helping them. It might also need to be accessed by staff who are working on billing records or filing, but you need to make sure that you limit access to that sensitive, confidential information as much as possible. Then you can also use this information to review for bias and compliance with client confidentiality requirements. By categorizing your data, you're taking the first step toward a really robust governance system, which is incredibly important. In our next section, we're going to talk about the core principles of data governance for lawyers. Let's turn to those core principles, which are especially critical in legal practice where the stakes are high. Now that we've discussed how to categorize data, let's turn to the core principles of data governance. These principles form the backbone of your data governance system, and they're especially critical in legal practice where the stakes are so high. So in this section, we're going to cover all of the foundational principles for good data governance and also some legal frameworks and regulatory frameworks that are really going to help you take care of the information that you have and use it appropriately. There are three primary pillars of data governance. The first is data lifecycle management, and that means every piece of data has its own life cycle from the moment that it's created until it's eventually disposed of. Managing this life cycle involves collecting data accurately and ethically and in compliance with applicable laws. Next, storage, using secure systems to protect data from unauthorized access. And use, establishing clear rules about how data can be accessed, shared, and used, and who has access to it. And finally, so to implement data categorization effectively, you need to start by auditing your existing data. You should figure out what data you currently have. You can use metadata tagging tools, either ones that you create or through a software specifically for this purpose. You can categorize data by how sensitive it is, what kind of data it is, and its usage. And then you need to define a policy for each category that you're going to have. You should have clear rules for how each type of data should be stored, accessed, and shared. For example, privileged client information might require encryption, while public information can be stored in a much less restrictive system. And then you need to regularly review and update your categories to determine, are these categories working for you? Is there anything that you don't need, or do you need to add an additional category? Data governance is not a one and done process. It's an ongoing process that you need to keep adapting as laws change, as your practice changes, and as your data changes. So you need to keep your data privacy policies evolving as your data evolves. Once data is categorized, it's crucial to ensure that access is restricted appropriately. For example, if you have privileged client information, the only people who need access to it are the attorneys who are actively working on it, the legal assistant or paralegals who are helping them, and then any office staff who might be involved in billing or other ways that they're involved in the case. Implementing role-based access controls where users only have access to the data that they're currently working on is a cornerstone of a really strong data governance plan. One thing to keep in mind here especially is if attorneys are leaving the firm, you need to make sure that you lock back down their access so they don't have access to privileged or confidential client information. By categorizing your data, you've taken the first step toward a really robust and effective governance system. So next we need to talk about the core principles of data governance for lawyers. The core principles form the backbone of any effective governance plan and are especially critical in legal practice where the stakes can be really high. In this section, we're going to cover the foundational principles of data governance, legal and regulatory frameworks that every lawyer needs to understand regardless of your practice area, and how gatekeeping and access control can enhance security and compliance. And by the end of this segment, you should have a clear understanding of how to implement these principles to protect your law firm and your clients' data. Number one, the first foundational principle is data lifecycle management. Every piece of data has a life cycle from the moment that it's created until it's completely disposed of. Managing this life cycle effectively involves collection. You need to ensure that data is collected ethically and in compliance with applicable laws. Next is storage. You need to make sure you're using secure systems to protect data, whether it's at rest, meaning just sitting at your law firm, or in transit, meaning you're sending it to somewhere else, either to opposing counsel or to another satellite office or whatever. You need to make sure that you are protecting that data. The next is use, establishing clear rules about how data can be accessed, shared, and used. And finally, disposal, securely deleting or archiving data when it's no longer needed in compliance with the retention policies, not only that are governed by laws dictating how long you need to keep certain information, but also by the policies that you set at your law firm. For example, a client's financial records might need to be retained for a specific number of years under a regulatory requirement. But as soon as you're done with that, you need to delete that information as soon as possible in order to minimize liability. The next core principle is roles and responsibilities. Data governance is a team effort, and every person has to understand their own specific role. Each person at your firm has a role that they're playing to ensure that data is handled appropriately. Some of the key roles are data stewards, who oversee the accuracy, consistency, and integrity of specific data sets, and data custodians, the people who handle the technical side of governance, such as maintaining secure systems or implementing cybersecurity applications that can help protect data. And finally, the end users, the people who are going to be using the information that you've gathered and stored. As lawyers, you have a dual role. You're both a data user and you're a data advisor on governance policies. The next core principle is policies and procedures. Really, at the heart of governance is a set of clear, enforceable policies that address how data is collected and stored and shared, who can access specific types of data, and how compliance with laws and regulations is ensured. These policies should be documented and then regularly reviewed, again, because data is not static. Data continues to evolve, and your collection and storage needs to evolve with it. Next, let's talk about the legal and regulatory landscape. As lawyers, we are already familiar with the importance of compliance, but the rise of technology and AI has added new complexities onto data governance and our data storage policies. For example, the GDPR governs data privacy in the European Union, with implications for all sorts of international data, whether the person that you're working with is a citizen of the EU or whether data will be transmitted to or from the EU. It needs to comply with the GDPR and with the EU's AI Act. The next key law is the CCPA, which focuses on data transparency and gives rights to California clients. This, however, should be implemented probably with all of the clients in your firm, regardless of where you're working, just in case someone moves to California or another state decides to follow the CCPA rules. Next is HIPAA, which covers sensitive healthcare data in the US. This is especially important for personal injury attorneys and anyone dealing with medical malpractice or any field where you will have a lot of data and records from medical treatment. And then there are also industry-specific regulations. Lawyers working in any kind of financial, healthcare, or education sectors should be aware of their specific rules, such as the GLBA or FERPA, or whatever other laws are going to be governing data gathering and data use. There are some challenges that come along with a multi-jurisdictional practice. So you need to be aware if you're handling or dealing with information across even state borders and also especially over national boundaries, you need to understand how those regulations overlap and how they conflict. For example, the GDPR might impose a more stringent rule than certain US laws. Especially, we'll see that when we come to incident reporting. There are strict rules that apply in the GDPR that don't exist elsewhere in the US. And then you also need to have AI specific considerations. AI makes everything move so much faster, and so it just really compounds compliance challenges by introducing questions about data usage rights for training models, transparency in automated decision-making capabilities, and bias and fairness in AI outcomes. Your data governance policies need to really explicitly address these issues to avoid any kind of malpractice or legal and reputational risks that your firm will be under if you're not taking care of data appropriately. And next is gatekeeping and access control. I mentioned this earlier, but it's important that you have a key person involved with gatekeeping and access control in data governance. The best way to handle this is through rule-based access controls, a system where only the people who are working on the data get to use those documents. And there's also the principle of least privilege. This principle ensures that users only have access to the data that they absolutely need in order to perform their jobs. For example, a receptionist who's scheduling client appointments probably shouldn't have detailed access to information in a client's case file. You also need to set up rules and assessments for tools required for enforcement. You're going to need some sort of encryption tool that protects sensitive data both at rest and in transit. You probably already have this. There are a number of different options, from technical systems that involve encryption to applications that you can use to transfer data safely and effectively. With that, you need to have audit logs, and you'll see a copy of an audit log in your materials today. You need to track who accessed or who modified data so that you can create accountability when something happens that you weren't expecting. Another really good idea for enforcement of data privilege is two-factor authentication. This will just add an extra layer of protection for any of your secure systems. So let's imagine a situation where a new associate, accidentally accesses privileged information not relevant to their role. If there were rule-based access controls, or RBAC, this risk would be mitigated entirely because that person would not have access to that data. This also makes it easier if lawyers are transitioning out of or into your firm, because you can easily give them access to sensitive data or quickly restrict their access to sensitive data. As a practical tip, you need to build your governance framework first. So a good idea is to start small. Define key roles for your law firm and then assign responsibilities for each one of those key roles. You need to establish those basic controls and then regularly review and update your policies so that you're reflecting the newest technologies and regulations. In fact, don't forget, if you're implementing any new technology, you need to be reevaluating all of your roles and your responsibilities and your access controls. Data governance frameworks are just what they sound like, a framework that you can use to build your data governance policy on. There are a number of different frameworks, but I've done a lot of research, and there are some that work better for lawyers than others. But frameworks are going to provide structure and guidance and really help you create a robust governance plan that is tailored to your firm's need. So I'm going to give you an overview of a few of the leading frameworks. Let's begin with 4 of the most recognized frameworks in data governance. Each has its own unique strengths and can be adapted for use in law firms. The first one is DAMA DM BOK. It's from the Data Management Body of Knowledge. This one was developed by the Data Management Association International, and it is really considered the gold standard in data governance. I really like it because it's comprehensive. It covers 11 key areas, including data quality, metadata, and governance itself. Some of its other strengths are that it is scalable, so it works for both small firms and for really large firms. And it's flexible. It offers guidance that can be tailored to specific industries, including legal industries. And it also focuses heavily on data quality, so it ensures reliable and accurate information that's essential for legal decision making. Using the DAMA DM BOK to establish a foundational governance policy is an excellent idea, such as data categorization and quality control processes. The next one that I want to cover is COBIT. It was created by ISACA. It's Control Objectives for Information and Related Technologies. Its focus is on aligning IT governance with organizational goals. So it really emphasizes risk management and compliance. Some of its strengths are that it's risk focused, so that really helps to mitigate risks related to data breaches or misuse. And it provides controls for ensuring compliance with laws like the GDPR or HIPAA, so it's got that regulatory alignment. It also has detailed guidance offering specific objectives and controls for legal IT systems. In your law firm, you can use COBIT to create a risk management plan for sensitive data, such as client communications or work product privileged informations. The third one that I want to cover is the Capability Maturity Model Integration. The CMMI framework focuses on improving organizational processes over time, using a maturity model to assess different capabilities and then identify areas for improvement. And its real strengths are that it's great for incremental improvement, which is ideal for law firms that are just starting off on their governance journey. It's also very customizable and it can be adapted easily to firms of all sizes. One of the things that I like a lot about this one is that it helps you track progress and set achievable goals. So it really focuses on maturity as you go through your data governance plan. You can use it to assess your current governance practices, if you have any, hopefully you do, and gradually implement improvements, starting with really high priority areas. The third one that I want to cover is ISO IEC 385051. I know that sounds like a lot. The ISO, it's part of the ISO standards, and it focuses on ethical and strategic governance of data with an emphasis on transparency and accountability. It is just globally recognized, so it's very strong for firms handling cross-border data. So if your firm is a global firm, this is a great one for you to consider. It's got an ethics-first focus, so it addresses the growing need for ethical AI and data use, and it aligns really well with ensuring governance supporting organizational goals. You can use this framework to address ethical considerations, particularly when you're integrating AI. All of these frameworks, all 4 of them are excellent. But what I like the best is a hybrid approach. While each framework has its own strengths, no single framework, in my opinion, addresses all of the unique challenges that are faced by us in law firms. That's why I suggest combining the best elements of each of these frameworks to create a governance plan that's really tailored to your needs. The way that I would approach this is starting off with the DAMA DM BOK framework and using it to build your governance policies and your quality management, and then layer on COBIT on top of that so that you can focus on its risk-focused principles to manage really sensitive client data. And then you add ISO and IEC just for the ethical guidelines and to ensure a lot of transparency, especially this is great when you're adding AI tools. And then CMMI to help your data governance progress through a maturity model. And then use CMMI for improvement. It can assess your current practices, and then you can track progress using CMMI's maturity model. This approach is really going to let you create a flexible, scalable governance plan that's going to be able to evolve with your firm. So just to break this down a little bit further, because I know all these frameworks can be a little bit overwhelming. You can start off with the DAMA, DMBOK, as a guidance to create something like a data dictionary, basically a catalog of all the data that your firm handles, categorized by sensitive to less sensitive to public, and all of them in between. Next, you can just bring in COBIT, and it's going to help establish some controls for privileged information, like requiring the encryption and the two-factor authentication. And I like that because it's got that technical element to it. And then if you layer on the ISO, IEC, it's really going to help you with data sharing with third-party AI vendors. And so altogether, these frameworks work so incredibly well together, are flexible and scalable, and just you can really tailor them to what you need in your law firm. The way that you really can bring these frameworks to life is by first, again, you need to conduct a governance audit. You need to consider your current data policies and processes and tools. And then you can identify some gaps. And if you don't have a governance policy or you don't have any governance tools, this is a great time to identify that and realize all your areas for improvement. You can also prioritize your high-risk areas and start there, especially if you're just starting off on your data governance plan. Start with your most privileged, most sensitive data, like your privileged client information, and make sure that you're implementing the most strict governance policies with that. Then you can also use technology to really effectively enforce these policies. You need to take advantage of tools to access control systems and encryption and audit logs so that you're not having to do a lot manually. You're just automating it. Then, and this is crucial, you need to train your team. You need to make sure that all of your staff understand the governance policies and their role, their individual role in protecting that data. Finally, you should review and refine this regularly. You need to make sure that you are staying up to date with the newest regulations, the newest technologies, or whatever your business needs are. So let's consider a real-world scenario. Let's say a mid-sized law firm experienced a data breach because its governance policies did not clearly define access controls for client records. If we had a COBIT-inspired framework, it could have mitigated this risk by establishing risk management protocols and audit trails so that we could monitor access. And similarly, if we adopted a DAMA DMBOK framework, those principles would have ensured better data quality and oversight, reducing the likelihood of unauthorized access. So if you feel overwhelmed by all four of the frameworks together, which I think is the best approach, then start off with one of these frameworks, and then you can add more or layer more on if needed, because that's an easier way to start off. Okay, so now that you have your framework in place, you're ready to address one of the biggest challenges in modern governance, and that is managing data in the age of AI. We need to dive into AI data governance. AI data governance is really a subset of data governance. So now that we've built our foundation with traditional data governance frameworks, we can focus on how to add AI into that. AI is really shaping how we manage, analyze, access, and use data. So it brings so many opportunities, but it also just introduces challenges that require a lot more tailored governance approach. So in this section, we'll talk about what AI data governance is and how we need to make sure that we are staying in compliance if we're using AI data. AI data governance oversees data used to train, validate, and manage AI systems. Unlike traditional data governance, it accounts for volume and velocity because AI systems handle so much information so quickly. It's very massive real-time data sets, and so we need technology in order to manage that data. It also affects dependency on quality. If we have poor quality data, it can really lead to biased or harmful AI outputs. And AI models are evolving quickly, and so there's a real dynamic nature to this, making governance, again, a continuous process. So imagine that your firm uses an AI tool to analyze discovery documents, which a lot of firms do. If they have an AI tool, a lot of firms have an e-discovery tool. If that's trained on outdated or biased data, its recommendations could really mislead your strategy. If you have effective AI governance, it will ensure that your data is accurate, ethical, compliant, and also explainable and trustworthy. I know that might sound a little surprising since sometimes AI or generative AI is called like a black box, but you can, if you use a system that is really more straightforward, it can be explainable and trustworthy. Another one of the challenges with AI data governance is that we don't see with traditional frameworks is the inherent bias from training data that AI models have. And that can lead to really discriminatory or unfair outcomes. So let's say you have a contract analysis tool, some generative AI application that you're using that might unfairly flag certain clauses in your contract based on patterns in its biased training data. Or one that we've seen actually a few years ago in real life was an AI tool that had biased outcomes in evaluating different resumes for jobs. The solution here is that you need to audit your training data sets so that you have inclusivity and use fairness tools. There are a number of different fairness tools that you can use. But even if you choose not to use one of those tools, you need to make sure that you're establishing guidelines and setting that baseline with a test and then continuing to monitor your AI data governance framework. The next challenge with AI data governance is data provenance and lineage. So you need to be able to train data clear from its source all the way through every stage of processing and all the way to when it finally gets deleted so that you are ensuring transparency. For example, let's say a client challenges an AI generated recommendation that you make. You need to have the records to be able to explain the data and the logic behind the output. And really, data AI tools work the best when there's a lawyer that knows what they're doing running the AI tool. So remember to keep yourself as the human in the loop, as the final expert on all of the output that you receive from your AI tool. But in order to help track the provenance and the lineage of your data, you should maintain detailed documentation of your data sources and the transformations and the uses. You should be able to find out the data lineage of your LLM from the vendor that you're using, whose AI tool you're using. The next issue is security risks. AI systems are vulnerable to unique threats, such as just adversarial attacks, where someone adds in malicious data, or even maybe they're more susceptible to cybersecurity attacks. So an example is if some disgruntled employee injects some false data into your AI model or into a RAG database, it can really lead to inaccurate contract risk assessments. So you really need to be careful to assess all of your data, and again, make sure that only people have access to the data that should have access to it. Another solution for this is to encrypt really sensitive data sets and AI models, and then test them for vulnerabilities regularly. You also need to be able to explain your AI systems and have accountability for your AI systems so that they're not just functioning as black boxes, making decisions that are hard to interpret. There's a new term called glass box AI, so AI systems that are explainable. For example, a tool that flags a document as risky but doesn't provide any explanation, that's not going to help you when you're trying to justify its findings to your client. You need to be able to explain all of the AI tools that you're using. So use explainable AI systems. There are a number of different AI systems that describe themselves as glass boxes instead of black boxes. And then make sure that you remain accountable for monitoring and validating the AI output. Finally, we need to be thinking about legal considerations for AI governance. Again, AI governance, it's not just a best practice, it's a legal requirement for us as lawyers. So we talked about these, but just very briefly, you need to keep in mind the EU AI Act, which is the first major legislation focused on AI, and it categorizes systems by high risk all the way down to very low risk. If you're not complying with these requirements, it can result in some significant fines and really affect your bottom line. The next one is, like we talked about, the GDPR, which governs data privacy in the EU and can affect cross-border data transfers. And then also the CCPA and HIPAA, which both affect AI data holding and data governance. And then don't overlook state-specific privacy laws or any court rules or bar rules that govern your technology use. For example, some bar associations might impose additional requirements for anyone who's using AI tools in their practice of law. And like we mentioned earlier, courts might have their own requirements. For example, a judge might have issued a standing general order that's going to require you to disclose whether you have used AI tools in your legal filings. So it's most important that you stay informed about emerging AI laws and really ensure that your governance plan addresses compliance at all levels. And it's always a good idea to stay compliant, if at all possible, with the very most stringent requirements so that you are best positioned to use your data how and when you need to. So to manage some of these challenges and legal requirements, you need to audit your AI system. You need to regularly be sampling random data output from your AI tools and just make sure that it's accurate and non-biased and fair. Like we said earlier, LLMs and AI systems, there's just inherent bias baked into them, and we have not been able to get that out yet. So you always need to make sure that all of the data outputs that you have are as unbiased as possible. One of the things that can help this a lot as part of your AI data governance is to have an AI ethical policy so that you're defining principles for fairness and transparency and really keeping everyone accountable for their own use of AI. You also need to hold your vendors accountable for all of their data and for its bias and unfair outputs. There should be some transparency requirements for algorithms and the training data because you don't want to have that liability if you have biased or inaccurate outputs. So you need to make sure with your vendors you keep doing regular vendor audits, and even if they tell you that they're doing a vendor audit, you need to still be doing your own vendor audit. You also, and this is again one of the most important keys, is that you need to train your team. You need to provide ongoing education about AI, how to use it, what the risks are, and the most ethical ways to use it. One of the most important things for your teams to remember is that truly they are the best form of risk mitigation. If they're reviewing all the output and if they're using AI tools as they're meant to be used, you are, and especially if they're double checking all of their citations, then that will go a long way toward helping your firm with data governance and risk mitigation. And finally, you need to make sure that you are always monitoring and refining all of your systems. One other thing that people don't often think about with a data governance plan is an incident response in data governance, but I think it's really crucial to have your incident response already planned out so that if the worst happens and you have some sort of data issue, you already have your response plan in place and you can go through the steps as quickly as possible. So let's just take a moment to talk about what happens when things do go wrong. Despite the best data governance practices, breaches and security incidents can still occur. That's why it's great to already have your incident response plan in place. Really, data governance isn't just about preventing problems, it's also about being prepared to respond to them effectively when problems arise. Different regulatory laws like the GDPR and the CCPA require that you respond really swiftly, and some of them have deadlines as short as 72 hours where you have to respond and inform your clients of a data breach and otherwise take steps to mitigate the problems that arose from the data incident. Your clients really expect you to protect their data even in the face of any kind of incident. So you also have an ethical obligation to safeguard client confidentiality. Let's talk about the key components of an incident response plan. A strong incident response plan typically includes 6 stages. The first one is preparation, then detection and analysis, then containment and eradication, recovery, and then finally post-incident review. Let's go back and talk about these a little bit more in depth. For preparation, you need to establish roles and responsibilities and determine protocols for who's going to do what in any given incident, such as a ransomware attack or an accidental data leak or a cybersecurity attack. You should train staff regularly and maybe even do some drills so that they are confident in identifying and reporting security incidents. The first step in responding to a potential data breach is identifying and analyzing the incident. This means that you need to understand the scope, the nature, and the potential impact of the breach as quickly as possible. There are tools like real-time monitoring systems, and in fact there are some in the frameworks that we talked about that can really help you detect unusual activities such as an unauthorized access or a really large file download. You also need to keep in mind regulatory timeframes. For example, the GDPR has a 72-hour rule. You need to act swiftly so that you can notify consumers or clients of a data breach within 72 hours of becoming aware of it, unless the breach is unlikely to pose a risk to individuals. This means that within that 72 hours, you need to identify the breach, assess its severity, and provide an initial report to the governing authority, even if you don't have all the details yet. In addition to that, if the breach is likely to cause some high risk to individuals, then such as exposing their sensitive personal data, you also need to notify the individuals themselves without delay, usually within the 72 hours. Although the only thing the GDPR requires is that you notify them with as much information as you have at that time. For US-based firms, laws like the CCPA also include notification requirements, though the timelines vary. For example, the CCPA does not have a specific deadline, but it requires that breaches be reported in a timely manner to all affected individuals. So include your breach notification protocols in your incident response plan. In fact, you should already have pre-drafted notification templates for regulators and clients so that you can just quickly and easily fill those in and get them to the place that they need to be if there is ever an incident. You need to assign someone like your data protection officer, like a DPO, or if you don't have a dedicated data protection officer, you need to assign someone at your firm to manage compliance with reporting obligations. Let's say your firm experiences an unauthorized access to a database containing client names and email addresses. Under the GDPR, you're going to need to notify the supervising authority within 72 hours. Even if you don't have all the information, you just submit an initial report and then you can follow up later. You also need to use detection and analysis. So use monitoring tools, really take advantage of them to detect that unusual activity. For example, if a lawyer notices unauthorized access to some client files, then the incident response team should be notified to try and figure out if there's actually been a breach or something else is going on. The next step is containment. As soon as you find out about a breach or some sort of security incident, you need to be working on containment so that you can limit the scope of the breach to prevent any further damage. For example, maybe you can isolate compromised systems or disable an affected user or do anything that you can to stop the breach from spreading. After you've contained it, you need to eradicate the threat. So identify and eliminate the root cause of the incident, such as maybe it's malware or someone having unauthorized access. You need to make sure that there's not going to be any residual harm. For example, if someone shared their password and it was used wrongfully, you need to make sure that that password is reset immediately. And the last step in the actual incident is recovery. Try to restore all of your affected systems and data securely as quickly as possible. This should really be something that your IT team is involved in, if you have a dedicated IT team, or your technology person. After you've gotten all of that taken care of and you're certain that your systems are back up and running, you should do a post-incident review. You need to analyze what happened, why it happened, and how you can prevent it in the future. Then you need to be updating your governance policies and training all of the members of your firm so that you can avoid an incident like this again and really learn from what happened. So first of all, you need to really develop your incident response plan. Then you need to identify your monitoring tools, then train your team and conduct regular security drills. Prepare for the notification like we talked about so that you have those already set up, and then be prepared for your post-incident review. All of those are going to help. If the worst happens and you do have a security incident, you will be much more able to handle it quickly and effectively. For this last section, I want to really go over some case studies and give you an opportunity to have some practical application of all of this into your firm. So we've covered a lot of principles and frameworks and strategies, but now let's bring it all together with some real-world case studies so that you have a better idea of what should happen, and so that you can become more familiar with strong governance and how you can use that to mitigate risks and improve your outcomes. So for this first one, let's start with a case study that highlights the importance of AI data governance. So let's say a multinational company adopted an AI tool to assist with legal contract review. The tool flagged a disproportionate number of contracts involving women or minority-owned businesses as high risk. Upon investigation, it was discovered that the training data used for the AI model reflected historical biases in how contracts were evaluated. So I want you to take a minute and just think what went wrong. Not only was the training data for the AI inappropriate, but the first concern is that the users failed to recognize that the output was biased. If they would have reviewed all of their output, they should have seen that before there was ever a problem. Second, the company failed to audit the training data for bias. And third, there were probably little to no safeguards to identify or mitigate for discriminatory actions. How could data governance have helped? Well, if they had been conducting regular audits of AI systems, the bias in their training data would have been discovered much earlier. So how could data governance have helped? Regular audits of the AI system's training data would have really uncovered the bias a lot sooner so that the firm could correct it. Implementing ethical AI principles such as fairness and inclusivity could have prevented this issue from ever happening. The firm also should have a framework that would allow them to quickly trace and correct the problem with their flawed data. Let's look at case study number 2. A mid-sized law firm outsourced its document review to an AI vendor. The vendor suffered a data breach, exposing sensitive client information. The firm faced reputational damage and legal action from affected clients. So take a minute and think what went wrong. The firm didn't include strong data security or audit requirements in the vendor contract in this case, perhaps. Or maybe there was no plan for responding to a breach involving third-party systems. A data governance plan could have helped by having a clear contract specifying encryption, and regular security audits could have reduced risks. And an incident response protocol would have minimized the damage and demonstrated the firm's commitment to protecting client data. So let's apply what you've learned with a scenario-based exercise. I want you to imagine for a moment that your law firm is evaluating an AI tool that will assist with client intake and risk assessments. The tool promises that it's going to streamline your processes, but you need to ensure it aligns with your data governance framework. So I want you to take a minute and think of how you would draft a governance checklist for evaluating this AI tool. Some things that you should consider are data quality and bias, what data was used to train the model, how the model's output was evaluated for fairness and accuracy, and does the vendor comply with regulations like the CCPA or HIPAA? And are there provisions for cross-border data transfers? Are there access controls that would provide who has access to what level of data? And are there role-based access controls in place? All of these things should go into your data governance plan. Especially, you need to give consideration to how will the AI system be reviewed for performance and compliance over time. You can look in your materials for an example of what a quality checklist might look like, and then you can modify that in order to best fit your specific needs. This kind of checklist will not only protect your firm, but it's also going to help build trust with your clients. Let's talk about a few key takeaways now that we've covered all the areas we were going to cover. The first key takeaway is that data governance is absolutely essential for protecting client confidentiality, ensuring compliance, and building trust. AI transfers governance by speeding everything up, and so you don't have that lead time that you might have had before if you're using AI tools. So make sure that you have a good quality framework, whichever framework you choose to use, and then stay up to date with all the AI laws, rules, and regulations that are going to apply to data governance. Also, make sure that you have roles already assigned for the people that are in your organization so everybody understands what their responsibility is and what actions they need to undertake if there's an incident. Next, training. One of the key takeaways that you should have from today is how important training is, and not just one-time training, but ongoing training. You should have a good initial training that helps everyone understand their role and responsibility in not only data governance, but also AI data governance. And once they understand that, it's important to keep training ongoing so that you're staying up to date with everything. And finally, have your framework in place so that you really have a good system to evaluate all of your information coming into your firm and all of the information going out of your firm. You know, data and information really is the most important thing in a law firm. We are our data. And if our data is not being handled well or being treated appropriately, then that is our biggest asset being wasted. So it's critical that you have a really good data governance framework and data governance checklist so that you can make sure that you are staying up to date and avoiding a number of problems that could have been solved by having a good data governance plan. And if you have any questions about implementing a good data governance plan in your law firm, or if you need help implementing AI and AI considerations into your data governance plan, please feel free to reach out to me. All of my contact information is at the end of these slides. And if I don't know the answer to your question, I'm even willing to look it up to help you out. Thanks for watching.